Chair, we have apology from Mr. McPherson and Mr. Mulder. I think both are busy with by-elections in their respective provinces, Chair, so they won't be able to attend today's proceedings.
Okay, we note those apologies. Can we have a move and a second for the adoption of the agenda? We will be getting a briefing from the National Consumer Commission on the fourth quarter financial and non-financial performance, and then also progress made in the implementation of the recommendations of the I think it's the inquiry on the timeshare industry. And we have a mover, Honorable Mbuyani.
Chairperson, thank you very much for the opportunity. I propose that we adopt the agenda as reflected. Thank you.
Thank you very much. We have a seconder for the adoption of that agenda? Members?
Chair, may I second the motion for the adoption of the agenda?
Yes, thank you very much. The agenda is duly adopted. Just give me a minute. I just want to have a sip of water. Okay. So now we are, first of all, as the agenda indicated, that we will have a briefing from the National Consumer Commission on its financial and non-financial performance for the third quarter for the 2022-23 financial year. This is so that the committee can assess the performance of the NCC against its resource allocation in compliance with Section 5 of the Money Bills Amendment Procedure and Related Matters Act of number 9 of 2009. And then secondly, later on in the briefing, the timeshare, the next item on the agenda will be the timeshare vacation ownership industry has been plagued by complaints and challenges in terms of non-compliance with consumer regulation. As a result, the National Consumer Commission embarked on an inquiry into the industry, which culminated into a report being published in 2018. The purpose of it being on our agenda today is to receive a briefing from them on the progress made in implementing its recommendations, if any. In addition, what further work has been done with the industry stakeholders for them to become compliant with the Consumer Protection Act, and whether any enforcement action has been taken subsequently. This has been an ongoing concern for the committee since the previous Parliament. Committee Secretary, can we check who's on the platform from the department to introduce the entity?
Chair, we received communication that Ms. Sandile Brown will do the introduction, Chair.
Thank you. Over to you, Ms. Brown.
Thank you, Chair. Good morning, Honorable Chair and members. Today on the platform from the department, we have Dr. Masocha and Ms. Matumela, and from the NCC, we have Ms. Tezi Mabuza, the Acting Commissioner. She's accompanied by the CFO, Ms. Philippine Mushidi, and the Company Secretary, Mr. Joseph Silolo, the Complaints and Investigations Head of Division, and also for the Head of Division for Enforcement and Legal, Ms. Prudence Moilwa and Mr. Jabulani Mbeche. Thank you. And we'd like to thank the committee for the opportunity for the NCC to present their progress. Thank you, Chair.
Thank you very much, Ms. Brown. Ms. Mabuza, over to you.
Thank you, Chair, and thanks for the introduction from the Department of Trade and Industry, and thanks to the opportunity given to us. Chair, I will start with the Q4 presentation, and then I will share my screen in that regard. Chair, thank you. This is our Q4 presentation, and to you just in relation to where we are, and in this area as presented, or maybe as introduced, on questions in this area will be supported by the Chief Financial Officer and also by the Company Secretary. And what we will be covering, Chairperson, it will be the regulatory context, the highlights, the performance information, the financial information, and progress made against audit findings. And looking at the regulatory context of the NCC is that we have been established based on Section 85 of the Consumer Protection Act. And what the Act really seeks to establish is to promote a fair, accessible, sustainable marketplace for consumer products. And even for that matter, what the Act does is that it sets the norms and standards for every legislation in the country that relates to consumer protection. What also the CPA does as well is that it ensures that there is, it prohibits unfair marketing practices and businesses, and also it promotes responsible consumer behavior. So that's why now, even when we'll be looking at the timeshare, you would see that our real focus is on enforcement of the framework that relates to consumer transaction and agreements. So, and when we are looking at the NCC and the CPAs, that when it comes to issues of consumer protection, we have concurrent jurisdiction with the provincial consumer affairs offices on issues of consumer protection. And also the mandate as well of the NCC in terms of the Act is also to recommend accreditation of any alternative dispute resolution agent or codes that will be part of the transactions that are covered by the CPA. And thereafter, the NCC will now monitor the efficacy, and then when the time is ripe as well, recommend some of those to minister to extend their accreditation. Now, the vision and mission for our strategic plan as the NCC, all that we wish for is to be proactive and responsive to ensure effective consumer protection. And our mission in this instance is to ensure that we tackle unfair business practices. We want to promote compliance to ensure redress, and then also that we do through advocacy, we do that through investigation, prosecution, and also we coordinate our efforts with other institutions that offer consumer protection so that we ensure that we continuously together educate consumers and ourselves, and we make sure that the research that we have is relevant, but then we also want to be seen to be fair. And in terms of the impact that we want to make to the economy in South Africa, we want to ensure that at the end there has been accessible, fair, safe, and sustainable markets for consumer goods and services in South Africa. Now, the highlights for this quarter. Chair, the one area that we had picked up throughout the year that we realized that it is actually a weakness or maybe a misunderstanding from some of our small businesses that are entering the import space, especially when it comes to clothing, textile, footwear, and leather goods. This area, we realized that when we took stock of all the goods that were non-compliant, we realized that those small businesses were not compliant. With the DTIC and the industry, we set up some regulations that we wanted to ensure that those suppliers understand them, even if it's in the Act. And then we went out on a campaign to make sure that we educate them. And then when we did the business guidance, 3 of those programs were focused on those small importers. And we had those sessions in Gauteng, around Gauteng here, because of the CTD. And then we went to Durban and also in the Western Cape. And then the other areas in terms of business compliance, the 7 were on any other programs that would deal with contracts and other provisions of the CPA. So for the quarter, we conducted 10 business guidance. And then for consumer education, we conducted 22 in-person consumer education and awareness programs. This we conducted in the townships and in the rural areas. And as you would also know that with our World Consumer Rights Day, we covered the areas, all the broader areas, all the district in the Northwest during this quarter, just to understand what is happening in there. And then hence now we were able to go to those rural places in the Northwest. And then we had done the 22 in-person consumer education interventions. And then when we did the enforcement and when we conducted our investigations and we had to enforce areas wherein there was non-compliance, our enforcement actions resulted in us taking action against 24 suppliers. In us taking that action, money back in the consumer's hands, just only for this quarter, it was 1 million wherein consumers were refunded for areas wherein there was non-compliance, and administrative fines that were levied against some of the suppliers during our interventions. It was 61,000 for this quarter. But then as we were talking around the issue of the compliance for the clothing, textile, footwear, and leather goods at the ports of entry, the compliance notices that we had issued translated into the value of those non-compliance goods to the tune of 5.2 million. So that we had instructed those suppliers to ensure that they either destroy those goods that were non-compliant or return them to their country of origin. And as members would also know that one of our biggest mandate is to remove products that are non-compliant from the market before they cause harm. So in our product recall notification, what we had received is that in this quarter only, which are new product recalls, were 11. As members would see, is that 9 of them were related to motor vehicles. And from the 9 that were motor vehicles, as members can see, 6 of them were related to Mercedes-Benz. 1 was on Lexus, and then the others was around the airbags that the Takata airbags for the Volkswagen app. And then we had then also 1 recall from the Isuzu bus as well. And then for the electrical equipment that also deals with the our power supply, alternative power supply. We looked at the area that was wherein we had a product recall. It was around Gizu, the 5,000 watts and the 3,000 watts. But then what happened is that in this, it's really for an emergency power supply. We worked closely on this one with the national regulator for compulsory specifications, just to check, because we know that they, in this case, they regulate the, in terms of now the acceptability of power bets. So we worked with them. We were comforted with their investigation now because they had to either replace or refund. Now they have received, the importer received new power banks, but then they had to go through the National Regulator for Compulsory Specifications. We received a letter confirming from them that these ones that they have now received were compliant, and then consumers now would be given new power banks. And then the last area of a product recall, it was around a catheter. And then this one was recalled because they felt, the manufacturers felt that there was some weakness in it in terms of letting in air. But then, as you know, that it is some of those that are, though there is a medical device, but then we had to be informed. We work closely with SAPRA in this case as the regulator for medical devices as well. And on around media coverage and what we do to bring consumer protection and some of the areas related thereof to the broader public. Only for the quarter, we had undertaken 52 radio interviews, as you can see, national, community, and regional. We had 6 TV interviews, and then we had 49 online media coverage. We had 28 sound bites. Sound bites is when we actually record the messages beforehand and give them to the media houses for them to tweak them as they want to disseminate the message further. And then we had 21 newspaper articles and 5 media statements that were issued in this quarter. And now for the performance of the NCC, I will just go back on the first slide. The NCC on the previous slide, we have 9 deliverables, but then for this quarter only, we achieved 8 out of 9, and we will expect we will explain further our challenge in relation to the area that we could not fully meet all our compliance in terms of our technical indicator. The first area that we had achieved, as I said previously, that our role is to monitor the efficacy of all the accredited ombud schemes. We have 2 accredited ombud schemes, which is the motor industry ombuds and the consumer goods and services ombuds. For this quarter, they had sent us their performance. We engaged with them. We wrote letters on areas wherein we see that there are some weaknesses, or maybe wherein we felt that maybe they did not meet their standards as set by the code. So we have achieved that area. And then also in terms of consumer education, for the quarter, our milestone was 9, and then we achieved 22. But also as comfort is that for the 2023-24, we have increased our target in this area to be at 60, because we know that when we work with other regulators, we can actually do more. So we have increased that in the next financial year. And then for the percentage in terms of the number of investigations, this is the area members wherein we did not meet our target fully. We had 35 investigations that we had as our workload. We finalized and issued reports against 31 thereof, and that gives us 88%. Though our target says 80%, we have exceeded in terms of the target. But then we set ourselves another standard to say that if we have commissioned an investigation, we have to finalize that within 90 days. But in this case, we exceeded the 90 days on average. We were at 97. This is because we had 3 other complex investigations wherein they went back and forth with some of the consumers and also requesting for further particulars from the supplier so that we can ascertain whether there is compliance or not. So we had exceeded our time, but then when we compare the times with the other quotas for the year, is that we have actually achieved this target as well. It was in this quarter in terms of the time that it took to finalize the 3 complex ones. But then on enforcement actions, this is when we take matters to the NCT. For this quarter, we had 8 matters wherein we could not reach settlement agreements. And then we had now to refer those matters to the tribunal. We had taken action on 8 of those matters, 8 out of 8, within 40 days after we had received the investigation report. We had went through and we realized there's non-compliance, and then we had to prepare papers and everything within 40 days and then file those at the tribunal. Yes, we had done that. We had filed all 8 of them. Now, for the report on product recall, this is one of the highlights that we had given to the members when we reported on the 9, but then on the 11, even if we report on the 11, is that with our processes, we will still have ongoing compliance monitoring that we do. Suppliers will still give us their reports to say that how far they are with certain provisions before we can close up that report and say they have fully complied. So we had monitored that, and then we had given those statistics, but then we have the reports, we know exactly which ones we are monitoring. And on the areas in terms of the area in supporting transformation of the economy and providing guidance, as we said that we had set ourselves a target of 8 guidance, but then for this quarter, we had 5. But because of the areas that we saw of non-compliance by the small businesses, hence we conducted the further 3 so that we can make sure that at least starting this financial year, we see less of those goods, especially from our smaller importers that we had to destroy. And then on explanatory notes that we normally publish, after we have maybe seen some kind of like weaknesses in some of areas of compliance, like maybe with the clothing and textile, we will either produce some guidelines or maybe provide some non-binding explanatory notes. And when we do that, we will be guiding both business and consumers, and then we will publish those on the website. And sometimes we will also publish that, share those with some of the members of the media. On the number of investigations now, just looking at the clothing, textile, footwear, and leather goods, we do this in support of the master plan on clothing and textile. Our role here is to make sure that every import that comes into the country is compliant with the standards that we had for this area, and also to ensure that any other non-compliance is dealt with so that we don't get proliferation of goods that are non-compliant in South Africa. Yes, we know that some will slip in, but then we try our best in terms of what SARS would have flagged for us to go and investigate. In this quarter alone, we had detention notices, 59 detention notices from SARS, wherein they alerted us to say that they have 59 imports that they were of the opinion that they are offending the Consumer Protection Act. We investigated, we went out to investigate. We had completed out of the 59. For this quarter only, we completed 52, and those we completed within 13 days. So our aim here is to make sure that we even further reduce the number of days because of the burden that these goods will attract when they are stored at the facilities waiting for us to inspect them. So we achieved achieved our target there. And again, as we said, that after people have violated, that would mean that from the 52 that we had finalized the investigations, we had realized that 6 of them were really not compliant. And then in this case now, we ensured that we either issue compliance notices or we take further enforcement by referring them to the tribunal, especially if we find that they would be serial offenders in this case, wherein they will be repeat offenders after we had issued, maybe initially issued a compliance notice. And Chair, now taking you to our financials. This is how our budget stands as the NCC. As members could see, the budget that we receive, it's really, we receive the government grant only, we are fully funded by the grant. And in this case, we do not generate any revenue, because even the fines that would be ordered against some of the suppliers, it goes straight to the national fiscus. We don't keep any funds. So our budget for the year was in total the 59 million, plus the interest that we had anticipated, that made our budget to go to 68 million. But then to year, in terms of the budget, the actual budget that we had, the grant remained the same, but then because of the favorable interest, that in terms of the increase in the interest rates, is that the interest that we collected, we exceeded that by 219,000. And then we also had interest from other receivables in terms of our debtors and also other income. When we have issues like telephone calls and all that, we have set a cap for ourselves. Any member of our staff that exceeds that cap, if it's not work related, they would have to pay back that money back to the state. So hence you will see the other, that would mean that is from those payments that we would receive. So that made our actual budget to come to 61 million, but I will explain it further here. So what happens is that though we have an allocated grant of 59 million, is that the DTIC transferred that in 2 tranches for us. We received 35 million in April, and we received the rest in October 2022. And then, as I said, that any funds that we are not using immediately, we invest them in the South African Reserve Bank, and then we earn interest against that. Hence the interest of 1.7 million. And this interest as well, we use it as seen to supplement our grant. And then come to our expenditure. This is our expenditure as in terms of the figures, but then I will just show the members that in terms of the budget, we had an annual budget, though it was 61 million. We have capital projects. The capital projects that we see here, we don't budget for them. If we have any rollover funds, like in this instance, we had money to build our back-end infrastructure that we received directly from the DTIC. This money is ring-fenced until we finalize those capital projects. And then also if we have money that, because we're working on accruals, then if we have commitments, then come at the end of our audit, then we apply to National Treasury, then we are allowed to keep monies where in its capital projects and they have been committed. So then it increased our budgets by 4.8 million. Hence now the year to date budget was 68 million. Now, in just explaining our expenditure trend, is that for compensation of employees, we had budgeted 56 million. And from that 46 million, we had spent 96%. Yeah, we had budgeted 48 million, budgeted 48 million, but then we spent 46 million, which is 96%. And then we had a savings of 3.4 million, which is 1.6 million. This is because we still have the position of the commissioner that is vacant, though we use some of the funds when positions would become vacant from time to time. We had 16 interns that also assisted and added on our complement, but then at the end, we still had the 1.6 million. And then under goods and services, as members can see, is that we had our budget of around 30 million. We spent 98% thereof, and then we only had 1.8 that was remaining. And then of the capital projects that were wherein we had retained funds, because as I said, that it's wherein we will ask for monies to be rolled in for our capital projects, because we are on an accrual basis, is that the monies that we had, it has all been accounted for, because we had, in this case, purchase orders already, and some of them have been delivered partially. And this is how they translate. As members would know, that the initial cost that we had, it was 4.8 million that we had in terms of our budgets. And this is how we had spent. As members would know, that we had some weakness because we did not have the back-end infrastructure in terms of ICT as the NCC. So as you can see, that our projects now revolve around building, strengthening our ICT in terms of accessibility, in terms of stability, and in terms of security, and also in terms of making sure that our infrastructure remains stable all the time. So the monies that we had spent so far in terms of the commitment, the initial budget, and the rollover, as you can see, that you can see even the rollover of our commitments for the next 3 years in terms of the capital budgets. And we will see that this goes to our LAN network, our service desk, and then it goes to Mimecast, which is our security when it comes to all the emails, as members can maybe know as well, is that we receive most of our work through emails, and it is essential that every email that gets into our infrastructure in terms of our applications, in terms of our hardware, it's well secured and it's well scanned in terms of malware and viruses as well. And then the little amount that we also had, we also procured for office desk in terms of our breakages and all that. And then we also wanted to further conduct the customer satisfaction survey, so that we can understand what is it that consumers are struggling with in terms of improving our services, so that we can keep on eventually reinventing ourselves and taking our services to the people. And then also the other sore point, though our website, it's still working, it's still current, but we wanted to bring them on par with the standards that are expected of any other website, wherein we can even make it accessible to people that in terms of sight that are being challenged, so that they can be assisted to access our website. And then we also wanted to ensure that the maintenance is current and all that. And the other area as well, in terms of ICT, when it comes to digitization, we also wanted to make sure that we integrate our finances, our supply chain, and the payroll system as well. And the rest is really maintaining our Microsoft. Members, as maybe I am really elaborating more on this area, is that this is the area that will touch on our area of digitization when we go out to the opt-out registry, because this is what has to support both the opt-out registry and the digitization that for now we have already rolled them into our production platform. So we are now simply piloting them at production so that we finalize the glitches, as we promised you that by May, we wanted to start now allowing consumers to file their complaints in terms of a self-service, just going to our website and finalizing that, while in the next year, we will start rolling out either other digitized systems as well. So now, in terms of our progress against audits, as members, just to let you know that we received what we will say a clean audit in this case, because we had no findings that were raised. We really had one or two housekeeping issues that we would normally deal with them through our risk management and with our strategy to move towards a clean audit. And then with our internal audit findings as well, we had one or two as well that related to the relationship in terms of the wording in our APP when we were reporting. We had dealt with that. We have dealt with those through Q3 and addressed them. And now when it comes to the key challenges, members, is that as you could see that when it comes to our budget, when we are standing at 96, at 98, and then even if we would have one or two positions like the one of the commissioner that is open, even for cost of employment, we are standing at 96. That would mean that we do not really, in terms of where we are, we do not have enough budget to even employ more warm bodies. Instead, when a position will become vacant from time to time, we would rather have interns that will give an opportunity for them in terms of the work experience as well, but they also complement the work of the NCC. And then because we are in such a dynamic environment, as when we would be conducting some of the investigations, let's say they are related to finances or they are more complex, sometimes we need more specialized investigators for this area. You would need sometimes your forensic investigators as well. Is that we need money within goods and services for us to be able to appoint, when there is a need, other law firms that will assist with some of the complex matters so that they actually strengthen us and embellish our structure when it comes to those skills that we don't have. And again, when it comes to issues of prosecution, we know that members, the more we take matters to the tribunal and then matters are decided in our favor, we had in this year only, I think even this quarter only, we had 2 matters where in one matter was taken to the appeals court and one matter was taken to the high court. So when we go to the tribunal, the fact is that even if a supplier would feel that maybe otherwise we have maybe misrepresented our reach or so forth, we are not settled with costs. But when we go to higher courts and the appeals court, is that we would need senior counsel, and sometimes but we are still lucky for now, because in this financial year, in all the other courts, there was no area wherein we were settled with costs. But if it happens that we are settled with costs, let's say of a client attorney basis, including the taxes, it might take a chunk of our budget, let's say $1 million or so. So this is an area wherein sometimes we have to have funds within goods and services to be able to assist us if this eventuality might happens. And the other area as well is the issue of the vacant position of the commissioner. As members would know that the NCC is just one of those rare entities wherein we only have a deputy commissioner and the commissioner, so as the accounting authority. But now, even if when in instances like this, where in the position of the commissioner is vacant, then I also act as the commissioner. It sometimes overstretches me because I have to do both operations and also do the governance side of it. So this is the area, members, that we think we really need your assistance. As I said, members, this brings us to the end of our presentation. Thank you, members. I will pause there and then I will check if maybe there will be any other questions. I will just stop sharing for now.
Thank you very much, Acting Commissioner, for that presentation. It's much appreciated. Members of the Portfolio Committee are now open for interaction with the presentation. I'll take your hands. Members, are there no questions to the...
Mr. Mbuyani, Chair.
Okay. Honorable Mbuyani.
Thank you very much, Chair. It's not a question, it's a proposal that if maybe we can get the other presentation, maybe because they are linking somewhere, when we'll be able to get some clarities in question after we have received the both presentations. Thank you.
Okay, that's a good idea. Commissioner, Acting Commissioner, are you ready with the next presentation?
Yes, Chair, I will share that. Let me just
Okay,
share
thank
that
you.
and then
You
start.
may proceed with that one, and then we'll take
Okay.
a question session afterwards. Thank you.
Thank you, Chair. Chair, thank you. Let me just grab some water. Thank you, members. For the implementation of the recommendations of the timeshare, as we had said, as the chairperson had opened, that we started this inquiry in 2018. And for this presentation, the colleagues that will be supporting me on this, it will be the divisional head in complaints and investigation, Ms. Milwa, and then the divisional head in legal and enforcement, Mr. Mbeche. And for the members, we know that it has been very long. I think in 2019 when we presented this report, but then just to maybe give some highlights to members is that our presentation will cover just the methodology. I'll be quick on that, the scope, the deductions, and then I will spend more time on just looking at your medium to long-term recommendations, and then the short-term recommendations, and then go on to the implementation of the recommendations from 2018 to date, and then look at the process by the regulatory branch of the DTIC in terms of the drafting of the regulation, and then we'll go to other interventions to date, then we will conclude. Members, when we established the inquiry, we started that we set up a panel in May 2017. We appointed 3 members to undertake the inquiry on our behalf. That is based on section 88.3 of the CPA. And then the inquiry itself was conducted through public consultations. The people that we consulted consumers that were complainants, the industry participants, the provincial consumer protection authorities, as we have concurrency with them, and then we also other sector regulators as well. Is that we had some translation services so that consumers and some of the other people could engage and express themselves in languages that they were comfortable with. And then we went through to all 9 provinces. So when we were looking at the scope of the inquiry, what we were looking at when we established the inquiry is that we realized that members or consumers that were consumers of the services, they became members of these clubs way before the CPA was established. But then some of them, as they started aging and all that, they had problems in cancelling the contracts. And then sometimes some of the members would be allowed to participate in this point system. But then because the points were so minimum, they would not even be able to kind of like secure any kind of accommodation as such. So they will forfeit some of their points. And then again, you would find that when members or some of their members wanted to go on holiday, because we know that most of the people would have young children, they wanted to go during school holidays. And then accommodation, there would not be sufficient accommodation during that time. And then also the alternative accommodations that will be provided would not be of acceptable level as well. But then the issue that most people complain about, it was the misrepresentation and the issue of the pressure selling. And also when people felt that they wanted to resell the points themselves back, and so that they can recoup their money, is that value that was given to those points was very minute compared to what they had paid. And then also the memberships were linked to membership levels that you would be either of a particular status to access certain accommodation. And then also the levies charged, they were unpredictable. You would have members of clubs that will sit and increase levies until to a point where it became unaffordable to some of the members. And then as we know that sometimes with the vacation ownership clubs, the AGMs will be held in only one province. That would mean that if it's only in Durban, the person in Limpopo down in Thohoyandou, they would not even afford to go there. And also what they realize as well is that if their members will complain, they would never have a recourse of assisting their members. Now, in terms of the deductions that we had received, is that, let me just check if I haven't skipped any space. In terms of the deductions that we had picked up, is that none of the complaints that we were dealing with really related to your conventional timeshare. Conventional timeshare is when maybe there will be a space, a hotel, or there will be a room or house, where a holiday house wherein there will be so many members that are sharing that, and your week, you know that your week is in this point. So none of the complaints that we received related to the conventional timeshare as we know it. But then it was about the point system. And what we realized as well is that it was more around oversubscription. As you know, that some of the consumers, when they wanted to go on holiday, there would not be enough facilities to accommodate them. But then the industry itself had set itself an association to deal with their complaints. But then because it was the industry self-regulating, they were not seen as being fair, and most of the complaints were not resolved of the consumers. But then we realize that now the Property Timeshare Controls Act of 1975 that deals with your conventional timeshare did not cover the point system that the consumers were dealing with. And then the property timeshare, as you see it was promulgated in 1983, while the Consumer Protection Act was promulgated in 2008. But then when it was promulgated, it didn't repeal the Property Timeshare Act. In this case, that would mean that the timeshare, Property Timeshare Act, or anything related to the timeshare was never covered within the CPA. And the recommendations that were made by the panel, the recommendations made were there to address the findings, and then they were categorized into medium to long term, and then the short term. So now I will start with the medium to long term. With the medium to long term, what the inquiry recommended is the issues of dealing with the management of the clubs themselves. As we can see that the issue of the meetings and the issue of the AGMs is that what it was recommended is that the clubs should make sure that members are able to attend. And what they had suggested is that because now they have members throughout the provinces, that it would be better that maybe if they would have provincial structures, that would become part of the AGM as well. And then that they rotate the issue of the hosting of the AGMs so that members are able to attend in their provinces, and also dealing with the issues of the complaints that the clubs themselves must have periodic customer satisfaction survey so that they can measure whether their consumers, the consumers of their services, are still happy, or maybe if they need to make some changes. And in relation to clubs they also recommended around the issue of the annual increases of levies, the fees and the charges, that maybe what they think should happen is that because now these levies, they are increased to such a point that members are unable to afford them, and then they become indebted, that they would propose that when the minister designate a specific regulator to enforce the Property Timeshare Act, in this case, then they should be able to deal with the issues of this levies, and then the regulation itself should make sure that members of these clubs are able to determine all forms of financial contributions that they have to make to the club. And then again, once the regulator has been designated as well, there should be a consultation with other relevant regulators, as you know, that it will be issues of credit, it will be issues of properties and all that, wherein there are issues of proxies and so forth, that this designated regulator can work with others to make sure that there is fairness in these issues. And the third area that was around the issue of the management of the clubs, it was around the rules to make sure that the NCC should consult with other regulators to ensure that members of the clubs are in a position to influence what goes into these rules, including the rights, the responsibilities, and any other financial obligation that has been imposed on the members themselves. And as we said, that the clubs don't have a complaints handling mechanism, is that the NCC was encouraged to consult with other relevant regulators to ensure that the code that the industry wanted to actually come up with, that includes a provision to oblige those providers to ensure that they have internal complaints handling mechanisms, and then that they also include sanctions, wherein when a consumer cannot gain access in terms of their complaints being handled, that there will be sanctions as well levied against the different clubs. Then the other area wherein the inquiry found that there are issues, it was around the issue of competition issues in terms of the structures of the clubs and how they have been. So here, the NCC was advised to consult with the Competition Commission to assess and determine whether, in terms of just the makeup of the division, wherein you have a member, you have the owners, you have the developers, you have the proxies and all that, that they do not actually offend any of the competition legislation. So what the NCC was advised, it was to approach the Competition Commission and the CIPC to check, as we said, on the horizontal and vertical restriction practices, and also to ensure that there are no possible conflict of interest around the members in terms of company law, as well, directorship, and the issues of gatekeeping. And also to
Ms. Manakaza, sorry, Commissioner. Ms. Manakaza, can you please mute?
Thank you, Chair. And also what the NCC was advised, it was advised to set up a working group or the committee as well that will comprise of the NCC and the Competition Commission to oversee matters that in this case now are competition issues that will be affecting consumers in this industry. And the one area that was really we would say the cornerstone of the complaints, it was around the issue of marketing. Here, what the panel said is that the panel said that the recommendation was to look at the issues of marketing wherein people were invited to presentations. So the panel recommended that what should really be discontinued immediately, be proscribed or outlawed. It was wherein consumers, you go to a supermarket and then you get somebody that gives you a scratch card and then they give you a holiday voucher, or they tell you that you have, there is a free motor vehicle that you can win, free flights and similar items. And then when you get there now, is that they will tell you you have won a holiday or a prize, or wherein they would also say to you, when you come to a presentation to claim your prize, bring your credit card along. And then if you do not bring your credit card, then you are not allowed to to claim your prize, which they said it was for free. And then the second area as well is that the panel said that now the NCC should look at the intricacies and the modalities that would assist in releasing some of the consumers from these contracts, especially wherein the contracts were concluded and members can show evidence that what led to them signing their contract was an unfair, as alluded above. And then also to ensure that wherein there is a presentation made, there should be, that presentation has to be recorded and copies should be kept and archived. And then in the event of a dispute, the club, the burden should be on the club, or the burden should be on the club, not on the consumer in this instance, because now normally in the law of evidence, whoever that alleges should prove. But then the inquiry said in this instance, for this type of transaction, the clubs themselves should be the ones that will produce the record, not the consumer. And on the other issue of marketing as well, as we said, it was the other high pressure selling. In this high pressure selling is that the people, when they go to this presentation, they will be told that now, this holiday or this voucher that you will get would only be valid when you sign your contract today, or the bonus points that we have given you would only be valid when you sign today. So that should be also prescribed as well. And then the statement as well, in terms of the statement of practice, what the inquiry proposed is that the NCC should develop some kind of like a code. The NCC and the Consumer Goods and Services should come up with a code or a guideline at the end that will now outline the behavior that should be expected. And then also it should have a conduct. And in such, the statement as well should be incorporated into the proposed regulation that was supposed to be drafted. And then also is that when that legislation is passed as well, it should contain the code. And in that code, what was prescribed is that it should be compulsory that entities that are within the club domain should provide training or courses to all their staff that is in the marketing and sales. And then there should also be a clause for stiff penalty if maybe those ethical lines are crossed, like your pressure selling, the issue of now your credit cards and all that. So that is what they had proposed. And as well, around the issue of the marketing agents as well, as you said, that there should be that code, and then also the training as well, and the accreditation of their agents. And as well, what was really important after the training is that it's number D, that when this presentation is being made to consumers is that the holiday club or the incentives themselves should never be portrayed or projected as an investment, because it's wherein people were told that you come in, you buy these shares or you buy these points, it's shares that you can sell, or maybe you can even hire out your points for you to get extra income. So that should be outlawed as well. And looking at the intermediaries or the agents that they had, is that the NCC should actually take action in terms of the CPA to ensure that if a person is an intermediary, should now make sure that they reveal, even when they do the presentation, that they are acting on behalf of, so that it becomes the principal, which is the club, becomes known as well. But then the minister must also be approached so that whatever information that is required, that it should be part of that regulation that would also tie in intermediaries. But then as part of the industry code regulating the industry, there should be this code of ethics that will be developed to be within the industry that regulates also the agents, and then that they should also undergo compulsory training. And then the other area as well that was raised on marketing, it was sales to vulnerable groups. As you know, that vulnerable groups in this instance would mean the elderly, would mean, even if we know that people are young, but a person that would not understand that contract just when it's presented to them, that they will need help in it being unpacked for them to understand what it means. It says that now, wherein consumers have been prejudiced, that they should be released from such contract, and then that the NCC should actually facilitate this. And another area that was an issue, it was around the issue of extension of reckless credit to some of the consumers, wherein that when a person comes in and they cannot even afford to enter or maybe to come up with that lump sum for the buying of the units, they will now even offer them credit. But when they offered credit, they never followed the prescript of the Credit Act in this case. So NCC was advised to refer such complaints to the National Credit Regulator to investigate, and then also to ensure that wherein there is refusal to cancel and there is reasons to show that in case there were no background checks that were made, that the NCC should investigate and make sure that such contracts were also cancelled, and then that there shouldn't be any entertainment by either ourselves and the National Credit Regulator, wherein there is a proposal from the industry, because already with our engagements, the industry was saying that no, yes, they can cancel, then they should come together and decide on the terms of cancellation. Let's say that everybody that wants to cancel, then they issue them, let's say, a discount of, let's say, 60% or so, then the consumer pays the 40%. So the inquiry said we should not allow that. And the other area as well, it was the issue of the disclosure that were not made, that now when in this case, it will be the club itself, and then they have a subsidiary of the club that they purport to be the person that is now giving credit to the consumer, that this should also be disclosed as well upfront. Now, the other area that was an issue was around the issue of contracting. And this one as well, we know that in terms of the Property Timeshare Act, in terms of section 12, in this case now, this has to be simplified because we know that these contracts, they said before, as if now somebody is buying a property wherein you own this in perpetuity until you sell it or until you transfer it to your heirs. Hence now people were held in contracts were in perpetuity. So what the panel was regulating is that the contract should be a fixed term contract, and then it should, if possible, come into the ambit of aligning it to Section 14 of the Consumer Protection Act, because Section 14 says that a contract should, a short-term contract is 24 months, and then if it is longer, it should now give the consumer, it should be to the benefit of the consumer to have a longer contract. So that is what they were saying here, is that, that no contract should be concluded. That would mean that if a contract is concluded, it should allow some time for the consumer to take this contract, consider it, and maybe as well look at disclosures and all that, and allow them some time to come back within a prescribed time, maybe in the regulation, to say that maybe within 10 days, the consumer can still cancel, not the 5 days that the CPA will be saying. And then as well is that the contract itself, it should be made obligatory that if the consumer is provided with a contract, the contract would only be valid, not when it's signed only by the consumer, but when it only becomes valid from the date that it is signed by both parties, and the consumer has received the signed copy as well, to allow them that leeway that we spoke about of the time to cancel the contract. And as we said, this also talks to the cooling off period, that the cooling off period should only start once the consumer has received that notification that their membership has been activated, and then they have been allocated a number. Then they can now, that is the time wherein they can consider cancellation. And then also what was raised as well is that when there will be matters in terms of the somebody either offending some of the clauses of the contract, is that any other matter in terms of the rules is that of the contract. It should be at the close, generally in the proximity of the consumer, not where the contract was signed, because we know that people would sign the contract in any other place, but the court from which they will take the consumer to, if maybe there's a violation, it was mostly in Durban. So that was also to be considered, and also the cancellation as such. And this is what I had also spoken to earlier on, is that we should not entertain the proposal by the club members of now dictating on how to cancel those. So the contracts in terms of now the monies that will be due to them. And the other area that was looked at, it was around the issue of the legislative reform. And in this case now, the area that was spoken to, it was that ministers should now look at now in terms of Section 8 of this Property Time Sharing Controls Act, and then prescribe any information that has to be disclosed in writing by the clubs, and then also now decide on which regulator should be delegated with that responsibility of administering the act, and also prescribe for the clubs to disclose an email address wherein consumers should be told exactly, if now you want to cancel, where do you cancel and how? And because we know that some of them said that you can only cancel through a registered letter. And we know what happened when the postal service was not working. But then what they also propose as well is that in terms of, as I said earlier on, in terms of Section 14 of the Consumer Protection Act, Section 14.4 is that the minister should specify or promulgate in the regulation the period of that fixed term agreement as it relates to the CPA. And the other area as well is that they were looking at a new piece of legislation that should be drafted, that should be modern and industry focused and comprehensive to now take into consideration all these nuances that were coming up and the permutations in this vacation or timeshare ownership. And then also either the creation or the regulation of a regulator that will be dealing with this new reformed legislation as well, and also to benchmark with other countries. We know that in certain countries is that the timeshare, the ownership of the timeshare is only curtailed to 3 years. And what also was going to be, what they also proposed as the 8th point is what it was around the issue of the points in the vacation ownership share, to say that there should be a clear statement in terms of the issues of the standard in disclosing the value of the points. Is that if you said somebody owns 3,000 shares, what is the value of each share? So that when they sell it, they cannot sell it at a loss. And then that there should also be annual valuation certificates if maybe the points are worth what the industry says it is. And then the other area as well, it was around the expiry and forfeiture of the points when a person could not be get the accommodation even if they applied during the time that they wanted to in advance. Is that when consumers now in terms of 28, is that when consumers now, their points will lapse, they have to be notified to be given that 3 years to say that within 3 years, then it will lapse, or maybe you can also accumulate that so that consumers know. And if maybe it lapses because consumers did not have a place and a space really, or a facility for them to take the accommodation, they should be paid back, including also their levies as well, because they could not use the facility. And then I think, yeah, this was number B as well, that they should be paid their monies and also the levy that they had paid. And on the instances where as we said, that the consumer face potential forfeiture of points due to non-availability, these points should be carried forward until the consumer is able to secure a holiday accommodation. And then on the issue of cashing in and resale of points, what it was said that there should be a platform wherein members can either cash in, exchange, or resale some of their points. And this methodology of valuation should be clear, and it should be privy to the consumers as well. And then it should be done in 2 phases. The inquiry proposed that it should be immediately through a regulation or a longer term, so that there should be a legislation that deals with that in terms of the platform to focus on this property timeshare. And then on the issues of the liability, as I said initially, that the contracts were held in perpetuity, because when the clubs were selling this, they were selling this as if there is a property that is tied to the points that were selling. And hence now they said that when you pass on, your heirs or your estate inherits. And we know that when an estate inherits, they also inherit the financial burden, the credits, and all that. So that would mean that if now the club says that this is an inheritance and then it's passed to your heir, then the club is required to disclose the full terms and conditions of the inheritance to ensure that the person that would say that I want to inherit, they should tell them that you will be settled with your levies, which is 12,000 or maybe so many thousands a year and all that, and then that it's in perpetuity. So all those terms should be disclosed. And then also they should provide a detailed explanation of the obligations that flow from this inheritance, as we said, management fees and levies, the fact that there is no guarantee of availability of preferred accommodation, and such terms should be written in bold. And now let us come to the short term. The short term that we were supposed to look at, as proposed by the inquiry, it was to look at the availability of the accommodation. As we know that what the inquiry said that there was overselling, and they proposed that there should be periodic audits of the accommodation available, and then that this accommodation should be able to translate into points, and they should ensure that the clubs should always ensure that there is availability. And then they said that although that there is a scope for this proposed audit, but then that the challenge that is there is that it should require that this proposed audit should take into account the points sold versus the accommodation that the clubs have. And then what also should be done is that every member should be treated fairly. It should not be saying that if you are in tier wherein you are an elite member, that you are the first one to get accommodation, and somebody maybe who is at bronze, then they are considered the least. So everybody must have equal access. And then the clubs also have to provide assurance of an independent auditor that will ensure that audits the club membership versus the inventory of the accommodation that they have and the points. And then the NCC should engage with the affected clubs so that we address the immediate complaints from consumers so that we ensure that they obtain redress. And the other area that also they wanted us to talk to, it was also in relation to just the quality of the accommodation, to say that in their system as well, they will be saying to members when they sell them that you will be given this, we own timeshares or we own our share in these properties. But then the properties were maybe graded 20 years ago when the club was set up. When you go there, the properties or the accommodation is now of such a low value that it doesn't even meet the stars that they would have proposed, that they should be the grading council should be the one that's better placed to look at the grading of some of this accommodation. And then if consumers would not get accommodation at a facility of their choice, they should be given an accommodation commensurate to the standard that they will expect. And then where in their specific complaints already lodged, then that the NCC should engage the Department of Tourism or the Grading Council on specific establishments against which complaints were raised. Now, on just miscellaneous matters, some of the matters that were raised by the inquiry, they wanted the NCC to also engage the information regulator around the issue of the violation of the POPI Act, because when they call you, is that where did they get that information, and how did they get all your details as a consumer and all that, and then also that on the clauses around the issue of debt collection and the issue of litigation, wherein they will issue a warrant in Durban, wherein they know that the consumer would not even have the muscle to attend such a court in Durban if really you are staying in Lephalale. So that is what we were, they said that here is that there should be that clause in terms of between the consumer and the clubs in relation to the place of residence or, of the consumer instead of what they were doing. And then also that the NCC should engage with the clubs in relation to the using of those unfair tactics in terms of Section 40 of the CPA, and also that the abuse of the bank debit orders by the clubs, wherein the NCC was supposed to also refer such matters to the banking of South Africa. And now the engagements now, what they said is that there should be ongoing engagements between the NCC and the clubs, so that the NCC should prioritize that we engage with each club, and so that now we can do that. And then to ensure that though the panel engaged with them in November over 2 days, and also in February over 2 days as well, that the NCC should further engage further with them, wherein the clubs had promised that they will make good, and then that complaints that require urgent attention should be those wherein the consumers are unable to meet their contractual obligations, or maybe they were also winded into signing those contracts, wherein they were sold shares when they were not shares. And what we did as well is that there were now regulators that the panel, in this case, said that the NCC should consult with. It was the Law Society of South Africa, the Estate Agency Affairs Board, which is now the property regulator, and then also the information regulator, the debt collectors, and the South African Revenue Services, and then the Companies and Intellectual Property Commission, the Banking Ombuds, the Provincial Consumer Affairs Offices, the IRBA for issues of audit, and also the Competition Commission. And then the engagement as well, that they were talking to the engagement with the industry on existing complaints. This is what they had proposed, that the proposal, because already FUWASA, which was their own regulation, wanted to come up with a self-regulation that the entity is biased and ineffective, and then that there should be an independent arbitrator or an ombuds that should be set up with no ties to the industry, and then also the effectiveness and the enforcement of the proposed regulation should make sure that there is a closer interaction when these regulations were being promulgated between with the NCC and the provincial consumer affairs offices, and then that there should be a campaign to educate consumers to ensure that they are aware of this industry as well and the practices, and then that the NCC should encourage professional and trade associations to develop their own codes and to enforce quality standards that guard the interest of consumers. So the also in the engagement, what they had also proposed as well is that there should be the proposed regulation should actually be industry specific and should address the impediments that consumers have in terms of the access to the courts and enable them to approach courts directly when there is complaints in terms of prohibited conduct. And then the regulation itself should develop a clear process for complaints handling and a handover between the NCC and the ombuds that will be established in terms of Section 82. And then in terms of the unresolved complaints, the inquiry proposed that the NCC should engage with consumers, update them on the extent of their complaint, and if maybe they have been resolved, and then also that the NCC should execute the recommendations in the report in connection with specific issues raised where the complaints have not been resolved. Now, let's come to what has been done in terms of the implementation to date. What we had done as the NCC after receiving the report, we made presentations to the following regulators so that they understand their recommendations within their jurisdiction. We consulted with the department, with the regulatory branch, and then with the Companies and Intellectual Property Commission, with the Competition Commission, as we said, with all these other regulators, tourism, consumer goods, the Estate Agency Affairs Board, debt collectors, the Law Society. So all these regulators, we made the reports available to them. And wherein there were no clarity, we also followed up with a proper one-on-one engagement in terms of the presentations. And then as the NCC, we also set up a team, a 7% team in 2019. We wanted to ensure that the recommendations of the timeshare inquiry were implemented. And then we engaged with the industry, the different clubs in this case, complaints that we already had, and some that were raised when they had that we had appointed a panel of inquiry. We had 1,230 complaints that were outstanding, that needed to be addressed immediately. And of all this 1,230, the NCC, with its interaction with the industry directly, we resolved 997. All these complaints were contracts that were cancelled, and there were no penalties that were levied against the consumers that wanted to cancel. These were consumers that showed that there was pressure selling to them, that they could either, some of them that they were already pensioners, they could not afford the amount of levies that they had to pay, and they also could not even go on holiday. So those were cancelled. And then we had 223 complaints that still came to us, and we realized that on this, the consumers themselves were not being honest on some of the issues that they had raised. They needed more of a mediated settlements. And in this case, we engaged the Consumer Goods and Services Ombudsman to mediate between the consumers and the suppliers. 223 of those were resolved through the mediated settlement with the Consumer Goods and Services Ombudsman. Members will see that when you add up the numbers, we have around 10 complaints. Those complaints that were outstanding, it's consumers that either maybe had abandoned their complaints, or they felt that were irrelevant, or they could not get to their complaints. It's either they just did not go forward with the process, or maybe they might have, some of them, because we're elderly people, might have passed on. We did not get interaction from them. Hence, they were not part of this resolution. But then what the NCC did as well is that we went further now around the issue of the engagement with the DTIC around the issue of the law reform. So we had, first of all, we engaged the DTIC in terms of coming up with the regulation to overhaul the archaic timeshare legislation. As you know, that it was a 1983 regulation, or to pass on regulation to address the immediate plight. But again, as we were engaging with the property practitioners entity in terms of the new act, we realized that the property, there was limited reform in terms of the sectional title schemes when they established the CISOs in 2016. And this reform as well was talking to the community schemes, and it only covered the clear sectional title scheme, the homeowners association, your share block, and all that, your retirement villages, but it did not apply to the timeshare scheme as it applies to ponds. That would mean that even the Department of Human Settlement could not, with their limited reform of the Property Time Sharing Act, deal with the problem at hand. So the work now around the overall of the timeshare, you know, to come up with a regulator still remains, and then to try and just address the gap. And what we also happened now is what the DTI had recommended in terms now the regulation itself, is that as the panel recommended a regulation that was supposed to be promulgated in terms of the 1983 Act. So this Act, members, was administered by then, and it was supposed to be by the DTI then, but just also to remind members that before, the Department of Tourism was still within the Department of Trade. So now the Property Time Sharing Act was straddling between the department in terms of the DTIC and the Department of Tourism. And then as well is that this as well, we thought that it would be within the department in terms of the Property Time Sharing Act, and then the regulation as such to disclose this regulation, to disclose actually further what was required, dealing with all the issues of your cancellation, the information that was required was supposed to be a regulation that was supposed to be now passed on by the minister, and also to delegate a regulator to deal with this once these regulations were finalized. And so, as we said, that we thought that the minister will deal with that. But then in terms of the progress so far in relation to the regulation, the DTIC and ourselves, we have been consulting each other, is that we try to come up with the regulation. But before they could finalize that, the DTIC had already commenced, as we said, to in their consultation, and also they also approached the Office of the Chief State Law Advisors on the jurisdiction and also on the powers of the minister to regulate this under the Consumer Protection Act. And based on that is that the aim was to make sure that the DTI acts within its legal prescript, and then we were not acting ultra vires while we were trying to address this uncertainty and close this gap. But then this consultation took longer than anticipated, as we said, that from the time the legislation was promulgated in 1983 to date, a lot of changes had ensued. Now, the challenges that were met is that it was unclear whether the department had the powers to administer the act as it stands, as we were looking at the period. And then also through legal advice as well, it was noted that the minister cannot just use the CPA for another legislation in terms of Section 20 to issue the regulations, as now the act, which is the Property Timeshare Act, was not repealed by the CPA. So the department now had to start afresh and determine actually which department can actually govern or administer the Property Time Sharing Control Act as is, and then to now proceed. And as we know that they were, however, we know that we could not do that through the CPA. And then as such now, there is a lot of regulation, legislative uncertainty when it comes to this area. And now, because now we knew of even then, before, while we were still struggling with the issue of the legislation, the NCC still, besides just closing or assisting consumers to cancel those complaints that we had, the 1,200 plus, is that the NCC still continues to receive complaints, and the complaints that we are receiving, mostly they will relate to your Airbnb, like your vacation Hub International and Travolution through your booking.com and all that. So though they would be saying they are timeshare, but we realize that in essence, they are just your ordinary complaints in relation to just getting accommodation. What we had picked up as well is that Vacation Hub International, what they will be saying, they were selling under their club as well, some kind of membership that will be saying that you will get discounted flights, you'll get discounted accommodation in these areas and these areas and all that. They all operated as a club. The NCC had received 247 complaints. And of the 247 complaints, we had resolved, in this case, 237. And again, here we had the 10 unresolved complaints. But of the 10 unresolved complaints, these ones were really against Travolution. What we had picked up as well is that Travolution did not want to cancel and refund consumers, even if they would have cancelled within the prescribed time. What we had then now, in terms of now our investigation, they had now refunded of the 10 consumers, 7 of them were refunded 65%. Yes, and in this case now is that from the side of the consumer, some of them were over and above the 5 days, but then there was some sort of communication between the supplier and the consumer, wherein we realized that the 65% was really reasonable and some of the consumers agreed to that. So we had 7 of those wherein they were cancelled. They were now refunded 65% of their the funds that they have paid. And this amounted to between 25,000 and 29,000 per consumer. And the 3 that we are still dealing with, we are now still assessing our report, because we think that in this instance, there is a clear offense to the Consumer Protection Act in terms of our section, wherein now it was around direct marketing, and then they did not allow the consumers to cancel. And other interventions by the NCC so far is that currently the timeshare, the clubs themselves, they had really abandoned their VOASA. Some of them have now subscribed to the CGSO, but then they will now, in terms of the complaints, they deal with the complaints as far as it relates to the service themselves, and in terms of the cancellation as well, and how they will conduct themselves. And most of these complaints will be now dealt with in terms of the mediated process by the CPA. And then in quarter 2, in quarter 3, and quarter 4 only, in quarter 18, the NCC received 18 of those complaints. And then in quarter 4, we received 3. This is still related to these 2 clubs. And then, as we said, we had dealt with them, or we continuously deal with them to ensure that consumers get the redress as quick as possible. And in conclusion, members, what we can say is that the inquiry itself received a lot of support from the DTIC, from the consumers themselves, and the just the consumer protection fraternity, other regulators as well, and the economic development departments in the different provinces wherein the consumer protection affairs officers are located, including some of the academics and the industry regulators that came through. And there was also international interest because other states or other jurisdictions in Africa, they wanted to see how we were dealing with these issues of timeshare as well. And then we also, comparing the barrage of complaints that we were receiving before the inquiry versus this time, is that we see that even if we do receive the complaints, as you can see that we received 18, and then in the last quarter we only received 3, is that we see that there is a paradigm shift or the posture change from the industry in the manner in which they behave when it comes to consumer-related issues and also their marketing strategy. But we still conclude that the legislative reform is still critical, and clarity has to be sought that it's either some kind of like a reform on the CPA to appeal the part of the Property Time Sharing Act, or maybe to come up with a new regulation to enhance the CPA. Members, I will pause there and I will end here and I will stop sharing. Thank you, Chairperson.
Thank you. That was a marathon presentation. Thank you very much. Members, over to you for interaction with both presentations. Members?
Ms. Soliana, Chair, and Mr. Malamatia.
Okay, Ms. Honorable Hloniana.
Thank you very much, Chairperson, and it's so nice to have you back, and I hope you are feeling better. We can still hear that you are not exactly 100%, and we appreciate that even when you are not feeling better, you are still here with us. Chair, let me take this opportunity to welcome the presentation. It was a beautiful presentation. It was properly presented as well and properly written as well. Chair, I don't have much to say, so I think it's just only 3 items. The first one that I want to ask the department is this, the consumer education. And when I say a consumer education, I mean that mama or that papa from Alex who may not understand their rights when it comes to you bought a door, but the door that you bought is not, is giving you problems. Exactly can the department take us through on what are the steps that an ordinary South African must do? How do you contact them to be able to raise such issues? Because I can hear in our presentation, the issues that are raised are also of high level, and people who have monies and people who are actually in a position of the haves. Now, my question is that when we're dealing with the have-nots, how exactly do they get into contact? Because let me tell you, Chair, for me to buy a tin of fish and only to find out that that tin of fish I bought have expired. And then when I want to, and that's a lot to me because I don't have money. I've used my last cents to buy this thing. How then do you get into contact with this department in order for them to be able to assist you with your rights as a consumer? So they must just give us a brief explanation so that if any of our viewers are listening, they understand how exactly do you get in contact and how do you get assistance with your tin of fish that you have bought and it was not up to standard or it have expired and all of that. Secondly, Chair, I just want to deal with, I think it was in the first presentation, the issue of the fair market promotion. I think it was on page 14. You know, our markets are dominated by 1 or 2 or 3 international sharks. One of those are like P&G, a multinational consumer goods corporation. They set the price. They set how much this product is going to be sold with. What exactly are we doing in making sure that we begin to grow our own markets that can deal with such issues? I mean, literally from the toothpaste we brush our teeth with, to a toothbrush that we use in the morning, to the soap that we bath with, to the lotion that we put, to the roll-on that we use, are not produced in this country. And they come and be able to give us, to say this roll-on is going to cost you this amount. And no one can argue because they dominate the market. So when they speak about the fair market promotion, my question to them is that, what are they doing in making sure that we begin to have a fair market? Because at this particular moment, you'll also have your Unilevers. Everything is dominated by one or two big corporations. And then according to me, Chair, there's no fair market there. And then, Chairperson, in the one of my worrying factors as they were speaking was the issue of the budget, Chair. You know, when the presenter was presenting that they don't have enough in the funds and they don't make money from outside, because whatever fines that they put in, it goes back to the fiscus. My worry is that we're going to end up having an entity that's supposed to be a shark, that's supposed to bite, but it will end up not biting, Chair, because if honestly speaking, as the presentation says, that so far they've never been dragged to High Court, and then there was no need for them to procure the services of a senior counsel. My question is, if that happens, because like I've just said, that you are dealing with international sharks, what then happens? Because they have more money than our department, our entity has that money to be able to defend and be able to say we were right. They must be able to be empowered. I do not know how, Chair, but maybe this committee can find ways on what happens if they can find themselves in High Court, and how do they get assisted to make sure that they get the best of the best to be able to defend the people of this country. And lastly, Chair, you know, the issues of clubs and the issues of timeshares have always been one of the most, I don't want to use the word gangster, but gangster in a manner that you were not sure people will buy these timeshares only for them not to be able to now use them. We're very happy that this issue has been looked into, because you come to find that a lot of middle class South Africans who are just trying to make sure that after working so hard, they are able to take their kids once a year to a holiday, you find that they end up getting very frustrated because of how this was structured then. And then now we've entered a situation where, you know, literally people are being robbed. I also want to welcome, Chairperson, that the issue of these people who will find you at the malls and say you have won a holiday, but you must attend a presentation, that their issue has been dealt with, because a lot of scammers as well were using that to say, especially down there in Durban beachfront, when they will come and say to you, no, you have won, but you must attend a presentation. And not only now must the person take out their time out of their busy schedule to go and sit in that presentation, but only to find out that you did not win anything and people are actually trying to sell you something. And that is just a wrong way of marketing. But all in all, Chair, we are happy with our entity, and continue doing your hard work. You may not have enough money, but continue to do your best and make sure that you give those interns as well good support so that they learn how things are done. I so wish your budget can be increased so that some of those specialized skills that you need, you are able to cover them. Thank you very much, Chair.
Thank you very much, Honorable Hloniana, and thanks for the well wishes for my recovery. Honorable Malamacha.
Thank you, Chair. Let me welcome the presentation, very comprehensive, detailed, easy to read and understand. It's not by mistake where the woman lead, strong black woman, we normally get good result as we are chaired by the woman here. Now, just this question on the NCC, this position of commissioner, as long as it's been vacant and it's not necessarily shown signs of being filled, and I don't think it's a good thing. When can we really see it being filled so that it assists? The other issue, Commissioner, I'm not sure on your three challenges. How best would we like to see the portfolio committee assisting? Because indeed, for the good work that we're doing, if you don't get much support, as we have highlighted, and to be specific, how best should we do, it might, in the long run, destabilize the good work. The other good thing that we have done and showed, especially on the importers, that education program that we took and how you deal with it in terms of the illegal goods and the destroying of those. Now, the issue will be what consequences management do we have in place to deal with the repeaters offenders after you've done such good job that you have done the educational program to highlight what is good and what is not, bearing in mind that we are now in business. It can't be correct that there are those who are doing intentionally, then you leave them that way. Chairperson, allow me to be short because this report is very comprehensive. It just needs to be supported. Thank you.
I hope you could hear the Honorable Member Commissioner. I couldn't hear him. Could you hear him?
Yes, Chair.
Oh, okay.
I could
No,
hear
that's
him.
fine. Honorable Mbuyani.
Chairperson, thank you very much for the opportunity. Chair, let me also welcome the presentation. It is very much informative and it's precise in terms of the presentation. Chair, just few clarity-seeking question here. One, will just check in terms of the working relationship between the entities that we have in the department and other government entities outside our department. I'm asking this question, Chair, because at the end of the day, when there are challenges, we will come back and need the CIPC or NCC or an NRCS. But where was that joint KPIs arrangement when all this thing was occurring? Chair, also the one of education awareness program and outreach in rural areas for more understanding of the entity and its mandate. Because as we sit here now, we only found out that this entity is dealing with such issues. What about the masses of our poor people on the rural areas that they are suffering of the same arrangement every day? Every day they are getting these services on the spaza shop, wherever that they are being robbed of their value. And I just want to check that in terms of their program of awareness in most deep rural areas. The other one, Chair, I think the appointment of a law firm and senior counsellors is as a result of not filling the vacancies that are vacant from the department. I hope so, but that's my question, that the appointment of law firms and senior counsellors, it might be as a result of not having the senior counsel and also lawyers are in the entity. The digitalization and the modernization program, where are we able to get and yielding the required results around that digitalization project? The issue of creation of new legislation and the protection of timeshare industry consumers. We have started already as a department, as an entity, because we have raised that issues and we see that is important to deal with that matter. But then now, I don't know whether you have engagement with the tourism department around the location of the regulation, whether it should be located in the trade and industry or it should be located in the tourism. But where are we in terms of starting that legislative process moving forward? I just also want to check whether the VOASA, the VOSA, is regulated, and if it's regulated, by which entity, by which department, so that we get a clear understanding. While we see that in that Travolution, we're not complying with the investigation, and seemingly it's one of the big conglomerates that they are sucking our people in South Africa. And I think this thing of payment, of paying back, why we are not banning this thing, not to be functional anymore, because some of these, they are committing the crimes because they know that our entities, they will just want to get 10% reimbursement and so forth. They are doing this deliberate because they know that they will pay back the money if it's needed. So I just want to understand our position there. Also, the possible horizontal vis-a-vis the vertical restrictive practices. Are we able to capture that? Are we able to move forward with it? What is it that you can do to at least alleviate this process? Thank you very much, Chairperson, for the opportunity. Let me also wish you well in this flu. Thank you very much.
Thank you very much, Honorable Yanis, and thank you for the well wishes. I think my question is for the department, because I saw in the presentation that the minister was supposed to designate a specific entity or a regulator. So I just wanted to check with the department how far we were the things that the issue of the regulator or an entity, how far is the department with that, and also other matters that were mentioned in the presentation regarding the role of the department in implementing the recommendations from this timeshare inquiry, because most of the presentation was on things that should be happening, but it's not happening because the entity or the regulator is not in place. Yeah, I think, and then also the commission has been acting, because the last time we met with the National Consumer Commission, it was also the same acting commissioner. So, okay, may I just ask the department if there's an update on the appointment of a commissioner, given their very limited resources and person power within the commission. Over to you, Commissioner, and of course to Ms. Brown from the department to answer the questions. Thank you.
Thank you, Chair. I will answer some of the questions, and then I will just nominate some of my team members to support where they can. I will just name them with the chairperson's permission. On the question that was raised by Honorable Hlonyana and Honorable Mbuyane on the issue of the rural education, especially for the person that buys a can of fish and all that, the CPA, in terms of consumer protection, we have concurrent jurisdiction on issues of consumer protection with provincial consumer affairs officers. On a matter, especially issues that were raised wherein a person goes in and buy a tin of fish or maybe a loaf of bread at a particular shop next to them, that is wherein you would see us teaming up with the provincial consumer affairs officers to make sure that the reach to consumers is as quick as possible, and that they also have a footprint. And the issue was as well raised by our Deputy Minister when we were in Northwest on consumer protection, to say that we sometimes come together as regulators only during World Consumer Rights Day. Why are we not seen throughout the year? We had promised that starting from this year, we will come up, even if we don't go to all the provinces throughout the year, but we will come together as regulators, come in with what we call a small sweep, wherein we will target just one province and make sure that we concentrate on that province throughout, maybe give ourselves a week there wherein we educate, we highlight, we speak the language of the province, just so that we strengthen one another, and then we bring in consumer protection as we may be to the person in the street. But then it has to be supported by also our provincial consumer affairs officers that become very active to the person in the street, because now where we are with our placement, we were supposed to look at matters of national interest, but then we see that the person in the street sometimes they would have issues, and then they would not even have a person closer to them, because we are not being proactive as regulators, especially at provincial level. It's an area that we really need to work towards, but then we are trying. We will see if maybe next year when we come to present before you, that maybe would not have shifted the landscape in that area. And then on the issue of the issue of the fairness of the market and around the issue of the dictation of the prices by those that are manufacturing. This is the competition issue, but I am going, my colleagues, Mr. Slolo, will address that fully, including also the issue of the legal fees. On the issue now, and this will also highlight as well, I think the targets that have set by minister around the issue of the pricing and so forth. My colleagues will be addressing them, and I'm sure as well Ms. Brown will also touch on it a little bit. And around the issue of the consequence management, wherein it comes to the issues of importers as raised by Honorable Madimeja here, is that we try as much as possible to educate. And then on the first instance, we will come up wherein there is violation of the CPA. We come up with a with compliance notices, and wherein a person offends for the second time and all that, we normally, even if there will be a compliance notice and also sometimes as well an administrative action, administrative fine, we'll also go refer such matters to the tribunal to ensure that just also on the tribunal to ensure that we even get an order from the tribunal against such an importer. But I am sure that my colleague, Mr. Mbeche, will address this fully as well. And on the issue of digitization and modernization, as referred to by Honorable Mbuyane. On this issue, Honorable Mbuyane, is that we are really moving towards the issue of digitization. As we said, that our platform to allow consumers to self-serve, and this one would only be on still around the issues of emails, wherein consumers will still be able to use our platform on an email, or maybe use that on their devices like their cell phones and so forth. We are looking into that. We will now, as we're saying that our pilot is advanced, and we were hoping that, and we will let you know that by the 1st of May, our platform should be ready, or 1st of June, our platform should be ready. It should allow consumers to file their complaints on their devices that will be linked to our website. That's why now you would see that all our capital projects, it's linked, or maybe it's mostly targeted towards our ICT capability, so that we find ourselves on par with other regulators and so forth. And on working with other regulators, as raised by Honorable Mbuyane on that case, is that on all our matters, as we said, that even when we are doing a product recall, that like as you saw with the Gizo matter, is that when the supplier would be like saying that, yes, we have requested for replacement, then we will check amongst ourselves as to who is the regulator that is also mandated to support us in terms of standards and all that. The DTIC has made it clear in terms of the cooperation between ourselves. We have the MOU with Competition Commission, CIPC, also the National Regulator for Compulsory Specifications. Hence now, also when we allowed them to say that now you can roll out with replacing those Gizos back, we sought the competency of our National Regulator for Compulsory Specifications to say, give us the test, show us, give us comfort that we'll never get such a repeat in terms of now those appliances overheating and so forth in terms of the batteries. So, but then when it comes to the issues now of the timeshare, the regulations and all that in relation to timeshare, I will allow my colleague Ms. Milwa to address this matter further. Chair, allow me then to allow some of the team members that are here to respond to some of the questions. We will start with Mr. Brown. We will go to Mr. Slolo, and then we'll go to Ms. Milwa, and then Mr. Mbeche, when there are issues, he will also add on. Thank you, Chair, from my side.
Thank you very much. Mr. Brown.
Thank you, Chair.
Oh, it's Miss Brown. Okay, I wasn't going to go to the department immediately. Can we first take the entity responses and then we come to the department, if I may?
All right, thank you, Chair.
Okay, thank you. Who's the next person from the entity?
It will be Mr. Silolo, and then it will be Ms. Milwa, and then Mr. Mbeche will come last.
Thank you, Mr. Silolo.
Thank you, Chair. Good morning, members. there was a question that was asked by Honorable Hlonyana about how persons in certain areas can contact the NCC. We have all the usual platforms of email, telephone, and walk-in, but also as the acting commissioner has explained, we will also be having the digitalized platform. In addition to that, there are provincial consumer offices, and those offices, they also have district offices. So consumers can either contact us or the provincial offices. On the dominance and pricing, the unfortunate part is that in South Africa at this stage, there is no price control. As such, prices are not controlled. However, the Consumer Protection Act provides that goods and services must not be offered or sold at prices that are unfair, unreasonable, or unjust. The painful thing is that the CPA does not define those concepts. So in this regard, we are collaborating with the Competition Commission in order to put a definition in those cases as and when they arise. In the past, during the pandemic, there were specific regulations that were passed. Those regulations contained a specific definition, but as we all know, they lapsed when the state of disaster was then uplifted. Tied to the issue of this price dominance and market dominance in general, and what we are doing to increase or create local production, we are, as the NCC, not necessarily so mandated, but because we are an entity of the DTIC, and I will not necessarily be speaking on their behalf, in the APP to which we also subscribe, there is a target that seeks to increase local production. Ours is to educate those that will be in the production space of the provisions of the Consumer Protection Act to ensure that the goods they will be producing are compliant with the law. It is true that we do not have enough capacity to handle all the legal cases we receive. However, as stated in the tribunal, we represent the matters, and when we are taking on appeal, we are now dependent on time. Where time is available, we then go and oppose those appeals ourselves, and where appropriate, put our cross appeal. Even myself as the company secretary now and then have to appear in the High Court to do those appeals. It really does take a lot of us, because then we find ourselves doing a lot to protect the consumers. The issue of the administrative fine has been dealt with. That was asked by Honorable Malimecha. Now, the question asked by Honorable Mbiano on the working relationship, the acting commissioner has explained the relationship within the DTI entities, but it does not end there. There are other entities of government and other departments of government that we work with to reach our mandate, such as the SAPS, the NPA, the Agriculture Department, and the Health Department. I'm just giving some of those that we collaborate with when it comes to, because we also are responsible for enforcing the law that involves what we call scams, we then work very closely with the SAPS and the NPA in this regard. And when it comes to, for example, your food recalls, the Department of Health and the Department of Agriculture, we work closely with them in this matter. Yes, and then the digitization process, as the acting commissioner has explained, indeed it is in the piloting phase because it will do two things. We will also be able, consumers will now lodge their complaints in that platform and we will interact with them, but also consumers will be able, or rather South Africans will be able to lodge a preemptive block against this direct marketing that we generally receive on our cell phones, our emails, calls, and SMSs. I thank you, Chair.
Thank you very much, Mr. Salolo. The next person from the department.
Thank you very much, Chair. My name is Susan Muva. As the Commissioner has said, I think the honorable members are correct in raising concerns around the issue of money being refunded and the problem still perpetuating. The Commission is very careful not to close investigations on the basis that suppliers are resolving or refunding consumers. The two cases that the Commissioner has referred to, the one of Travolution as well as the one of VHI. In our investigation report, we have been very careful in highlighting that the conduct, and also because of the fact that it involves so many consumers, we just leave it just because they are refunding. In fact, experience has taught us that suppliers, when we start to investigate them, they will be quick to want to refund consumers as a way of trying to circumvent us from prosecuting or continuing with further enforcement action. So the honorable members are correct that just the fact that they are refunding consumers should not then end up with the Commission not proceeding with further enforcement action or taking punitive action against suppliers who are involved in this kind of practices. So as a matter of practice, we actually look at the number of complaints as a means of showing or demonstrating, even to the tribunal, the conduct of the suppliers that need to, in fact, be punished and also make sure that they stop the conduct themselves. The other question related to VOASA, yes, Honorable Member, the VOASA is not regulated. And we are looking forward to the designated entity or department that will assist us with the further regulation, because the way that the Commission's approach, in fact, this was the first of its kind, the inquiry was the first of its kind in trying to make sure that we deal with the detail that the Commissioner has presented now, to show that we deal with each and every aspect of the conduct in that particular industry. Hence the regulations, we are looking forward to them being promulgated and the clarity around which entity or department would deal with this regulation. And I think the recommendations by the timeshare inquiry will actually assist with the regulation as well as the entity that will deal with it. Thank you very much.
Thank you very much. I think it's Mr. Mbeje next. Who's the next person, Commissioner?
Thank you. Thank you, Chair. In fact, I'll deal with two questions. The one, it's the first one, it's a consequence management, which I will couple together with one question which was asked as to why have we not done away with the admin fines, because these companies they know very well that they can afford to pay. Well, I think with respect to consequence management, I think Commissioner did address most points. However, I just wanted to highlight that, in fact, when we issue compliance notices, we even instruct the defaulting companies to destroy all the goods that are non-compliant at an authorized agent. And then we get certificates that in fact those goods have been destroyed. And also we also sometimes we also direct them to return the goods to their country of origin. And thereafter, once they've done that in consultation with SARS, we will get a certificate confirming that in fact, indeed, those goods were returned to their country of origin. And then I'll move over because the Commissioner has touched it that in fact, where there are second offenders, we usually we prefer to refer the matter to the tribunal so that they can authorize or issue administrative fines. But that brings me to the question that in fact these companies they can afford to pay fines, and why have we not dealt away with the issue of fines? I just want to highlight that in fact, as the regulator, we act within the four corners of the CPA, and the CPA has not yet criminalized the actions of the defaulting parties, except where in fact the party has not complied with the judgment of the National Consumer Tribunal. But at the present moment, we are bound to act within the four corners of the CPA. We don't have more powers to take this matter or this matter to be regarded as a crime. However, I think the issue of the amendment of the CPA is within the jurisdiction of the Department of the DTIC. Maybe they might look at that issue to consider criminalizing those actions. I think that's all from my side. Thank you.
Thank you very much, Mr. Mpeche. So it's now over to the department. Ms. Brown, will you be handling the, it's Dr. Masocha. Proceed.
Thank you, Chair. Good morning, Chair. Good morning, honorable members. From the DTIC side, in terms of the questions that were asked, raised by the members, I'll start with the education and awareness. I know that the Commissioner has touched on it and Mr. Selolo as well. We also do education and awareness, and we do our best to ensure that it's in the local areas, in district municipalities, and we work with the communities. And the Consumer Protection Act is one of the key legislation that we raise awareness on an ongoing basis. So this is part of our program of ongoing work that we do as a department. And when we undertake those sessions, we work with the NCC. We also take along other regulators like the CIPC, the National Gambling Board, to engage the communities and to educate on the work of the department. As Commissioner has indicated, this is a function of concurrent jurisdiction with the provinces. So as she has outlined that process of how complaints are handled, we also receive some of the complaints, and we do route them via the NCC And we also note the role that is played by the Ombud, the Consumer Goods Ombud in this area, because they play a very important role as well to ensure that consumers' redress is addressed and consumers get their complaints are handled in a very efficient and as much as possible way possible. But noting the role of provinces as well and the suppliers on some of the direct handling of the complaints, because they also have a role to play, not just from a government side. I thought to add that point. On the issue of the economy and the dominance, Mr. Sololo talked to that, but then the Competition Commission does market inquiries and they look at issues of excessive pricing, and they continuously observe what is happening in the market in terms of different products. But the issue of pricing is the core of their mandate. They're the ones who deal with those issues related to the pricing of products and the pricing, and also issues of market dominance, where certain firms dominate the economy and they also phase out other role players. And it's a very crucial issue because of the importance of ensuring that there is a level playing field for other small businesses that are also operating in the consumer protection space and in business in general. So the question is very important because it also talks to the issue of the economy and how firms and their concentration affects the way that consumers then are affected in terms of how prices are determined. But the the Competition Commission is the regulator best placed to address some of these issues. But we know that they're actively involved in terms of monitoring the market, also addressing issues of enforcement when it comes to regulators or suppliers who are not complying with the law when it comes to issues of pricing and affecting the market in a negative or adverse manner. And then I'll talk to the one about the acting commissioner, just briefly. We are aware that we have been having a vacancy for some time, and that there's a deputy commissioner who is taking the helm in terms of the role and leadership of the NCC. So to respond to the question about the processes, there was a process previously where the post was advertised and there was a process that was undertaken. This is an issue that we will then take back to the department. We have noted the questions from the honorable members. We know how important this issue is, and to have a very strong, well-functioning National Consumer Commission that is ensuring that the consumer protection, consumer rights are addressed on an ongoing basis. So it's an area that we've noted from the discussions, Honorable Chair and Honorable Members, and it's something that we'll then take back to the department in terms of the next steps of what we can do to ensure that we close this vacuum. But we note that there is that leadership area that we still need to address as the department. And in terms of the legislation, and I'll tie up all the questions, including the one raised by the Honorable Chair, in terms of the regulator, and also the gaps in the regulatory framework and the regulations. We have been working very closely with the NCC since they presented to us the outcome of the inquiry. There has been a gap in terms of the jurisdiction of the legislation. Although the Consumer Protection Act is a law of general application and it's applicable in terms of addressing most of the issues, especially some of the issues related to contracts and complaints handling, when it comes to the time sharing in industry related issues, with the other laws like the Property Control Share Act, we've had challenges in terms of the jurisdiction issues. However, we have been working actively to try to close that. Part of the engagements have been on the consultations. We've consulted with one of the departments, Department of Tourism, just to understand in terms of where they are and the jurisdiction, because they do have a role in terms of the timeshare industry. And also, as the commissioner has indicated, they have been involved previously, even as part of the department at some point. However, we have not yet reached a point where we can give a concrete response to say this is where the jurisdiction is. So one of the areas we've been looking at is the issue of the possible where it can be possibly located in government, because there are other departments that may also need to be consulted further on that. There are draft regulations that we did prepare. However, because of this legal concern of jurisdiction, it was difficult to put them out because of that, those legal questions. However, we are still working on that process to try to see how those regulations can be vetted. We're not saying it's the ultimate solution because of the fact that they still need to be properly vetted, given that the law, when it was the correct legislation that we must use was quite limited. And a lot of areas have changed over time, including the role of the minister, the powers of the minister, where the jurisdiction of the department is. That's what has made this whole process very complex. What we can indicate to the committee is that we are working on this. We are aware of the agency of the regulatory framework around this. In terms of the CPA, the process of amending the law is quite lengthy. And this is one of the options that we will be looking at as well, to see if the CPA, when it's amended, it can then deal with some of those gaps in terms of what laws to be repealed, how it can be strengthened to deal with this industry even better. But we also want to ensure that we consult further in government to ensure that at least the relevant department can address some of these issues in a more coherent manner. So that is a response for now. It's not a very firm response because we are still working, it's still work in progress. However, we are aware that it's an urgent matter, and we are still trying to see if we can still have some draft regulations or regulations that can be processed further while we are trying to sort out jurisdiction issues and the issue of the regulator, because that has to be established in a particular legislation. And currently that is a vacuum as well. And is a role that the NCC is playing, but it's not fully playing it given the challenges with the legislation. So I'll stop there, Chair. Thank you very much.
Thank you very much. Is there any other responses? If none, I think what we've just heard from the department, fellow members of the portfolio committee, we need to schedule another interaction with the department on the NCC and the outstanding matters, both on timeshare and general matters relating to the NCC. And I think we should maybe just look to have another engagement, not maybe with the entity, but with the department, or maybe both. We'll see how to take it forward, to see what progress has been made and to be briefed on a timeline, because we note the important mandate of this entity in consumer protection, in dealing with unfair business practice, promoting compliance, ensuring redress. So I think it would be good for the committee to instead of just seeing them once a year, or to have a follow-up before we rise at the end of the year with the department and the entity if needs be. But thank you everyone from the National Consumer Commission and also the department for your presentation here today and for interacting with the committee in doing our oversight. Thank you very much. Can I just check with the committee secretary if there are any announcements?
Thank you, Chair. Just with regard to next week's program, Chair, we have scheduled to engage with the DTIC, NEF and IDC on the support provided to township economies. It's also our intention to bring the first draft of the International Study Visit Report for the committee's consideration, as well as the first draft of the third quarter financial and non-financial performance report. And then the 31st, we are having the Competition Tribunal on its strategic annual performance plan. So those are the events for next week, Chair. As indicated, it's our intention to distribute the draft reports either Friday or Monday for the latest for members' consideration, Chair. Thanks.
Thank you very much. Thank you very much. That concludes our business for the day, and the meeting stands adjourned. Thank you very much.
Long live the chair, long live the chair.
Thank you, Chair.
Thank you very
Recording
much, sir.
stopped.
Thank you, Chair.